Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, a partner at the Immigration, Medical Malpractice, and Business Litigation law firm Kurzban, Tetzeli & Pratt, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by EB5 Support. Not sure what to do when a client asks you about the EB5 investor visa or how they can choose the right EB5 project? That's where EB5 Support comes in. Founded and led by veteran immigration attorney Irina Rostova, EB5 Support helps investors navigate the entire process of EB5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists. Doing business as Invest America. This podcast is also sponsored by Gonzalez & Gonzalez Immigration Bonds. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez take it from there. In business and family-owned for 75 years, Gonzalez & Gonzalez helps other families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process and typically get refunds within 1 to 2 weeks of receiving the I-391 notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your clients stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They've got those too. Give Gonzalez & Gonzalez a call, check them out at immigrationbond.com, or click on their special link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Got a lot to talk about at the top of this episode. First, the new EOIR regulations regarding the BIA that everyone's talking about, so I might as well talk too. As Ira Kurzban notes, these regulations appear to be a mass deportation scheme to violate the due process rights of appellants. The portions requiring, in most cases, 10 days to file a notice to appeal and summarily dismissing things unless the BIA and banc steps in. Seems like the BIA isn't so concerned about the rights of non-citizens. Seems like the BIA is being weaponized. And of course, once there is a final order from the BIA, DHS can then fast-track the removal of such a person. And again, that expedited briefing process, my goodness. Nowhere else in American law would this be okay or in accordance with due process. We'll see what happens. Strap in, guys. Also this week, the Minnesota Chief Judge, I believe, listed almost 100 violations of federal court orders in Minnesota by the Trump regime. And everyone is, of course, talking about that federal prosecutor who asked to be thrown in contempt so she could sleep because she hated her job so much and was overwhelmed. Reports are that she was fired shortly after that. But can I actually come to her defense a bit? I'm not seeing that so much in the immigration community. First off, I believe she wasn't an AUSA, but was instead an ICE attorney special assigned to assist the AUSAs. If I'm wrong about that, I apologize. But not only does it appear she wasn't close to sufficiently supported in that endeavor, but it also just highlights the astonishing fact that DHS and DOJ decided to go to war with Minneapolis, but did not really think about how they could defend themselves in court, forcing them to then rely on temporary, reassigned attorneys. That is either gross negligence or a ploy designed to ensure that ICE doesn't have sufficient attorney oversight, and which was destined to lead to this moment. Either way, it's horrible. And then when the chief judge calls DOJ in to atone for their client's blatant disregard of 100 federal court orders, they send in this young person who isn't even an AUSA and obviously doesn't have significant authority to make ICE and CBP operations change much of anything. What kind of U.S. attorney, or at a minimum the chief of the civil division, lets a low-level temporarily assigned attorney take the heat at a contempt hearing from the chief judge? How was the U.S. attorney or civil chief, him or herself, not the one in the room answering those questions? To me, and unless I'm missing something, that's a scandal in and of itself. On top of everything else the federal government is doing in Minnesota, of course. And hey, if I missed something there, let me know, DOJ. I'm always happy to admit error for reaching a conclusion based on facts that I didn't know. Sure looks bad, though. Sure looks bad. Finally, after I wrote this and after I recorded everything, actually, late Friday night, a split Fifth Circuit ruled contrary to literally what hundreds of district court judges have already ruled, and got itself to be the first circuit to get the matter of Hurtado issue and affirm the government's position. No bond for UEs in the Fifth Circuit, it appears. I'll do the decision in depth next week. Sigh. For now, though, let's focus on the mostly good. Lots of them this week. Let's talk about them. Let's feel good. Hello, everyone. Our first case is Miot et al. V. Trump et al., published by a district court judge in the District of Columbia on February 2nd, 2026. As you all surely know, the Miot team, of which myself and KKTP are a part of, won this case in district court this week. Or that is to say, we defended the government's motion to dismiss and obtained a stay of Secretary Noem's termination of TPS for Haiti and all attendant benefits. DHS begrudgingly updated its website just after actually termination happened, and then appealed. It's an 83-page decision, and it's a bit of a bomber. Should you ever find yourself litigating a temporary protected status case in federal court, it has very important analyses of the TPS statute, which is what is required to terminate and what is not allowed during the termination process, and some heady jurisdictional analyses, including some very important stuff on INA Section 242F1. And that's just the start, really. Give it a read. I'm not going to do it like a regular case, given its length, and given that the rationale doesn't really apply to the vast majority of listener cases. Instead, I'm going to give you some quotes that try to remind the world of our plaintiff's humanity and of the issues at stake. This first quote is responding to Secretary Noem's own quote. Quote, "Plaintiffs are 5 Haitian TPS holders. They are not, it emerges, killers, leeches, or entitlement junkies. They are instead Fritz Miot, a neuroscientist researching Alzheimer's disease; Rudolph Civil, a software engineer at a national bank; Marlene Noble, a laboratory assistant in a toxicology department; Marissa Laguerre, a college economics major; and Verbrun Dorsenville, a full-time registered nurse." End quote. To say that this 83-page decision is wonky is to say quite the understatement, and I invite you to read it all. It is truly enlightening what our government is attempting to do at present, how committed it is to cruelty, and how willing it is to violate laws and procedures that even during Trump 1, it was at least making an effort to appear to be complying with. There is an exceptional description of Haitian country conditions, too, in this decision, by the way, for copying and pasting into any case where Haiti country conditions matter. To say nothing of Mr. Trump's racism and unabashed xenophobic hate, string cites summarized by the court in multiple pages because it takes multiple pages just to give examples of it. Miss Noem, too. Then there's this as well, quote, "The court is sensitive that its role is not to weigh the record itself. If it was, this memorandum opinion would be considerably shorter. Secretary Noem is the decision maker, but the secretary cannot just throw verifiably inopposite or false assertion after inopposite or false assertion, no matter how inflammatory, against the wall and hope that something sticks. Nor can she lawfully fail to consider the very factors, such as economic considerations, that she herself has determined are relevant simply because they do not support her preferred outcome. End quote. At the end of the day, I believe this passage a good summary, really, of everything that's kind of going on. Quote, finally, the balance of equities and public interest favor a stay. The government does not cite any reason termination must occur post haste. Secretary Noem complains of strains on lawful immigrants placed on our immigration enforcement system. Her answer? Turn 352,959 lawful immigrants into unlawful immigrants overnight. She complains of strains to our economy. Her answer? Turn employed lawful immigrants who contribute billions in taxes into legally unemployable. She complains of strains to our healthcare system. Her answer? Turn the insured into the uninsured. This approach is many things. In the public interest is not one of them. End quote. And I'm sorry, but I can't end without the court's own conclusion. Quote, there is an old adage among lawyers. If you have the facts on your side, pound the facts. If you have the law on your side, pound the law. If you have neither, pound the table. Secretary Noem, the record to date shows, does not have the facts on her side, or at least has ignored them. Does not have the law on her side, or at least has ignored it. Having neither and bringing the adage into the 21st century, she pounds X, formerly known as Twitter. Kristi Noem has a First Amendment right to call immigrants killers, leeches, entitlement junkies, and any other inapt name she wants. Secretary Noem, however, is constrained by both our Constitution and the APA to apply faithfully the facts to the law in implementing the TPS program. The record to date shows she has yet to do that. End quote. So congratulations to us, Ira, myself, and KKTP. Especially Ira as well, because a lot of these legal arguments really follow from his McNary win at the Supreme Court many decades ago. To Sejal Zota and Just Futures Law, to Raymond Audain, to Steve Forrester, who's been fighting these fights as long as Ira, and most importantly, to Jeff Popoli, Andrew Tauber, and their team at the law firm Bryan Cave. You have done exceptional work and dedicated so much time to these worthy humans and the immigration community. And it ain't over. In fact, as of the time of this recording, the government has, as I said, already appealed and believes the harm to it, the government, your government, so harsh and terrible that it's seeking an emergency stay of this stay. Who voted for these guys? But tonight, and surely even as of the Tuesday listening that you all will do, over 350,000 human beings and their families are being protected in America who might not otherwise be protected. And that is Miot et al. V. Trump et al. All right, hopefully that pumped all of you up as we trudge through the BIA this week. First, matter of GMI. This case is about expert witnesses. It was remanded by the BIA under the previous administration, and when the immigration judge granted cat protection on remand, DHS appealed under the current administration. The BIA under the current administration has sustained DHS's appeal and overturned the EAJA. Mr. GMI is from China and has a serious drug conviction in America. He sought Convention Against Torture deferral after serving his criminal sentence. On remand and after according an expert's witness statement and testimony full weight, an EAJA found that Mr. GMI would be detained and tortured upon return to China for committing drug crimes and causing reputational damage to China. I often say on the podcast that it's getting impossible to win cat and asylum cases without an expert. With an expert, too, it appears. Like in all courts, experts are there to assist the finder of fact, explains the BIA. Here, that's the immigration judge, no juries. Quote, the testimony of an expert witness is less helpful when it merely interprets common types of evidence that immigration judges regularly encounter and do not need expert assistance to understand, such as country condition reports and news articles, end quote. And expert testimony isn't weighed heavier than other evidence, notes the BIA. When deciding what weight to give expert evidence, explains the BIA, the EAJA must ensure that the testimony has a, quote, sufficient factual basis, end quote, quoting its own expert case law from 2020. As everyone knows, an expert's opinions are not conclusive. The opposing side, for example, can rebut it. Or, increasingly in the immigration world, the neutral arbitrator IJ can, all but explains the BIA. If there are factual contradictions, an IJ should explain why the expert's inferences are the more persuasive, which is kind of flipping what it said in 2020 on its head, in my opinion. And also, with sufficient prep, I would say that a true expert is the most persuasive person in the room on country conditions. But, quote, an immigration judge should not merely defer to an expert's predictive inferences, especially when those inferences are based on commonly understood generalized evidence and essentially establish a factual finding or legal conclusion, end quote. Not merely defer, though, doesn't mean not important. Anyway, here explains the BIA, the expert's affidavits and testimony opining on the likelihood of torture includes country condition articles, which of course is proper. But to the BIA, the expert didn't have a sufficient factual basis to make the conclusions that the expert made. This is all after being certified as an expert, presumably, by the way. First, explains the BIA, the expert didn't have direct knowledge of the extent of China's torture, which would be kind of insane if he did, right? And even the expert admitted that, quote, there is a paucity of statistics, end quote, of such things from China, because of course China is not a free country and tries to cover things up. That ambiguity, however, somewhat cruelly, cuts against CAT applicants and experts, explains the BIA. Quote, although we cited a law journal article stating that 95% of death sentences in China involve drug crimes, international homicide, and robbery, this statistic was not broken down further as to how likely a person convicted of drug crimes was to receive the death penalty, or the likelihood of the death penalty being inflicted on individuals like the respondent who were convicted of drug trafficking in another country, end quote. Quite the burden, guys. Quite the burden. The BIA proceeds to tear apart other parts of this certified expert's opinion, nor is there any discussion whatsoever of whether DHS successfully cross-examined the expert or presented its own contrary evidence. Quote, the relevance and reliability of an expert witness's opinions are significantly undercut when those opinions are informed by anecdotal or inaccurate facts or data, end quote. Believing the anecdotes relied on by the expert, quote, not analogous, end quote, to Mr. GMI, the BIA all but cast aside the certified expert's opinion and overturned the IJ. Turning then to the merits of the CAT claim, without a probative expert report, the BIA had little trouble vacating the grant. Quote, even assuming the Chinese government will likely become aware of the respondent's drug conviction and detain him upon arrival, the expert witness's opinion that the respondent will likely be tortured relies upon the same kind of anecdotal and generalized country condition evidence that we have explained does not establish a sufficiently individualized, clear probability of torture, end quote. As I keep kind of saying in jest, the BIA wants video evidence of the non-citizen literally being tortured in real time to grant CAT protection. Quote, evidence of the general possibility of torture does not meet the respondent's burden to show that he, in particular, would more likely than not be tortured, even if some similarly situated individuals have suffered torture, end quote. So remember, guys, we're theoretically talking simply a 51% likelihood. Mr. GMI has not, quote, presented sufficient evidence of any particular or specific interest in him by the Chinese government, end quote. Rather, it's more based on country condition evidence as applied to him, which is very often the case in CAT claims, which the BIA very much knows. And so Mr. GMI gets sent to China, and the BIA issues a shot across the bow on expert testimony. And that is a matter of GMI. Another one for the BIA this week, a short one, matter of Yadav. This case is about sua sponte motions to reopen. Mr. Yadav was ordered removed in 2014, but was not physically removed. In 2017, he married a U.S. citizen and applied to adjust to lawful permanent resident status, but USCIS refused to adjust him because of the outstanding removal order, as is USCIS's want. So Mr. Yadav moved the BIA to reopen and likely terminate his removal order so he could adjust to green card status. His motion is, of course, well over the 90 days, though, generally required of motions to reopen, but such motions have had varying degrees of success across different presidential administrations. And in any event, there's always sua sponte reopening if the BIA wants to be nice to someone who they believe deserves it. The BIA is not interested in being nice here. Sua sponte reopening is reserved for, quote, exceptional circumstances and is not meant to cure filing defects or circumvent the regulations where enforcing them might result in hardship, end quote. Plus, explains the BIA, citing itself from last year, there is an important public interest in the finality of immigration proceedings. Motions to reopen undermine finality. Indeed, they seek to reopen. The BIA believes that Congress did not intend sua sponte reopening to be a widely used exception to the statutory motion to reopen rules and limits. Quote, our administrative role in the immigration system, which is to faithfully apply the laws and regulations, cautions us to exercise this authority sparingly and only as an extraordinary remedy reserved for truly exceptional situations, end quote. Moving on then to quite the rule, the BIA holds, quote, a motion to reopen sua sponte that is based on equities acquired while remaining illegally in the United States after being ordered removed generally does not establish a truly exceptional situation, end quote. But no equities developed during that time? Like if you have a U.S. citizen child and the child develops cancer and you treat him and only you treat him and you're a great father, none at all? BIA can't mean that. Yet their quote here lacks limits. Well, the BIA then does say, quote, only a truly exceptional situation would warrant us exercising our sua sponte authority to reopen a case based on equities acquired after a valid order of removal is entered, end quote. So maybe my hypothetical does cut it. Not met here. As explained by the BIA, this is simply a marriage to a U.S. citizen, and U.S. immigration law is A-OK separating U.S. citizens from their spouses. Quote, respondent's valid marriage to a U.S. citizen entered into after a removal order does not constitute an exceptional situation warranting sua sponte reopening of removal proceedings, end quote. And that's it. And that is matter of Yadav. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial Advocacy College. Registration is now open. The annual Immigration Court Trial Advocacy College convenes every year in April, only in Kansas City, Missouri, hosted by the Pen and Sword, that awesome community resource founded by Reka and Michael Sharma Crawford. This year, the program has been reimagined and reworked to address the current climate of aggressive deportation enforcement. These times are not ordinary, so the program had to be extraordinary. Expanding from 3 to 4 days, the Trial College provides comprehensive training from beginning to end, real cases taught by real litigators in real courtrooms. The skills you need, the confidence you deserve, and the mentors you look up to, all in one place. Register early to avoid disappointment at www.thepen-and-swordkc.org or at the special links in the show notes. Use special code ImmigrationReview26 to get $50 off the Trial Advocacy College this year. That's capital I, capital R. All right, we ate our BIA vegetables. Moving on to Michelin et al. The Warden, Moshannon Valley Correctional Center et al., published by the Third Circuit on February 2nd, 2026. And I promise I did not intend to make a culinary pun just because the plaintiff in this case was called Michelin. That was just a tasty coincidence. In this decision, the Third Circuit held that you can obtain attorney's fees under the Equal Access to Justice Act for winning a habeas case. Very important. Provided, of course, that you win, which almost surely means that a federal judge grants the writ. Also, as with all EAJA cases, you must show that, quote, the government's position was not substantially justified or special circumstances make an award unjust, end quote. Both of the non-citizens here, by the way, were prolonged detention cases with final orders of removal, and Mr. Michelin even appears to be mandatorily detained based on a criminal record. Just saying. Still won, still getting EAJA fees. The reason that you can get EAJA fees is because habeas petitions demanding immigration detention release are indeed civil actions. The Third Circuit spends many pages explaining why, which you should copy and paste from should you need to litigate this in your circuit. I'll not get into all of it, given that I did much of it a few months ago in the 10th Circuit's decision, Daly v. Choate et al. episode 289. There's a circuit split with the 4th and 5th circuits on this, it appears, with the 2nd, 9th, 10th, and now 3rd circuit on the side of fees. So even though I'm not doing all of this, I wanted to go in depth more than simply doing this at the top of an episode, as I mentioned, to ensure that the case appeared on the podcast page, but also because there's a lot of great habeas quotes from this decision and on detention. I'll end with some of them. Quote, "The government had no reasonable basis in law for contesting," one of the petitioners, "for a bond hearing after over 16 months in detention without one. We have spoken clearly. Detention becomes more and more suspect after 5 months." End quote. The Third Circuit then closes by, quote, "echoing the Supreme Court's recent reflections on the historic role of the writ of habeas corpus." End quote. Now continuing on, partially Third Circuit, partially Supreme Court, quote, "When English monarchs jailed their subjects summarily and indefinitely, common law courts employed the writ as a way to compel the crown to explain its actions, and if necessary, ensure adequate process, before allowing any further detention. The great writ was, in this way, no less than the instrument by which due process could be insisted upon. It remains so today. With this history in mind, we affirm." End quote. Go forth and get your fees. And congrats and thank you to Arnold and Porter for the win. And that is Michelin et al., the Warden, Moshannon Valley Correctional Center et al. Moving on, we have Montejo-Gonzalez et al. V. Bondi, published by the banc 9th Circuit on February 5th, 2026. The cases are so favorable to non-citizens this week that I'm doing an banc favorable to non-citizens 9th Circuit decision towards the end of the episode. Ano ba yan? This is an banc decision about in absentia reopening. Judge Friedland concurred and Judge Nelson, joined by others, dissented. And yes, I remember this one. The family that got caught in traffic on their way to their hearing in Seattle and so were ordered removed in absentia. They had their timely motions to reopen denied, but the 9th Circuit reversed that on episode 234. The en banc court has now taken it up, but back to the family. It was a 1.5-hour trip to court that would have gotten them to court in time with much time to spare, but that day, 2 serious traffic accidents made the trip last almost 4 hours. Unrepresented by counsel, Ms. Montejo-Gonzalez tried to document what was happening the best she could during the drive and spoke to 2 clerks at the court that day. Their subsequent motions to reopen even had photos from the accident attached, along with news alerts. An immigration judge was not swayed and denied the motion. The BIA wasn't swayed either. To reopen an in absentia removal order in this manner, a respondent must show that exceptional circumstances prevented them from attending their hearing. Traffic problems weren't good enough for the agency here. A 9th Circuit panel reversed, as I mentioned, and now the 9th Circuit en banc has affirmed that. Now true, the statute itself defines exceptional circumstances to be, quote, "such as battery or extreme cruelty to the non-citizen or any child or parent of the non-citizen, serious illness of the non-citizen, or serious illness or death of the spouse, child, or parent of the non-citizen, but not including less compelling circumstances beyond the control of the non-citizen," end quote. But that doesn't mean that's an exhaustive list, explains the 9th Circuit. That just means that those are examples, and that the circumstances that caused the failure to appear must be beyond the non-citizen's control and be sufficiently compelling like those examples. It's a case-by-case analysis. And while not exhaustive, quote, "evidence relevant to the statutory factors may include whether the petitioners were diligent, whether they encountered external or unforeseen circumstances, and whether they lacked a motive to evade the hearing," end quote. Other factors, of course, can be relevant too, but whether a failure to reopen will lead to an unconscionable result is, unfortunately for non-citizens, not one of them. To the extent the 9th Circuit said otherwise in Hernandez v. Garland, episode 55, and Montejo-Gonzalez et al. V. Garland, episode 234, those portions of the decision now appear overruled by the 9th Circuit en banc. And I'll be honest, the 9th Circuit did say that in those cases, the unconscionable result thing, so that's too bad, and it might be why the 9th Circuit went en banc in this case. At the end of the day, though, again, it's a totality of circumstances approach, that is, extraordinary circumstances reopening, something that the Ninth Circuit believes aligns with the First, Sixth, and Seventh Circuits, and even BIA case law. But importantly, there is, quote, no per se rule that a traffic delay cannot be an exceptional circumstance, end quote. To the extent that prior Ninth Circuit precedent can be read that way, you're reading it wrong, explains the court. As applied here, the agency erred for multiple reasons. First, they failed to consider whether the traffic conditions were sufficiently compelling and beyond Ms. Montejo-Gonzalez and her family's control. And heck, even, quote, BIA precedent has also found similar road conditions, multiple accidents, and severe traffic on the highway sufficiently compelling to establish exceptional circumstances, end quote. That's a matter of SLH. Seems the BIA also held against Ms. Montejo-Gonzalez her being nice and sincere and apologizing for her delay in the affidavit, which it looks like the BIA read as a concession that she was at fault for not showing up at her hearing on time or something like that. But not only does that misread the affidavit, explains the Ninth Circuit, it's exceptionally cruel, explains the Kevin. Reminding the immigration agency of our shared humanity, the Ninth Circuit states, quote, a petitioner's attempt to express remorse or accept responsibility does not defeat a claim of exceptional circumstances, end quote. Nor did the agency consider all the contemporarily diligent things Ms. Montejo-Gonzalez tried to do to correct this. Pretty important. And a quote to remember, quote, there is nothing inherently unreasonable about planning to arrive at a hearing 15 minutes before it starts. Indeed, even if ordinary rush hour traffic made petitioners slightly late, a petitioner who arrives late for his immigration hearing, but while the IJ is still in the courtroom, has not failed to appear for that hearing, end quote, under very old Ninth Circuit precedent. And also, even say a 30-minute or hour cushion wouldn't have helped here, as the car accidents made the family 2 hours late. Applicable to many precedential BIA decisions these days, quote, the BIA must consider petitioner's diligence based on what a reasonable person would do under the circumstances without the benefit of 20/20 hindsight, end quote. Anyway, read this decision carefully as well when helping to edit affidavits from your clients in similar situations, as the Ninth Circuit explains why all the things Ms. Montejo-Gonzalez said here and in her affidavit are important to her success. Particularly as the family, quote, lacked motive to evade their hearing, end quote, and for all of the reasons explained above, the full en banc court remanded, taking with it the opportunity to get rid of the unconscionable result factor, which I did enjoy so much from those other cases. Still very much a win, though, so congratulations Catherine E. Munyan, Nicole R. Fox, and Daniel A. Rubens of Oric, Harrington, and Sutcliffe LLP, as well as Tina N. Malik from San Diego. And that is Montejo-Gonzalez et al. V. Bondi. En banc. Picture this. It's 10 p.m. on a Friday. You finally sit down to dinner when your phone rings. A panicked client just received a USCIS denial and has no idea what to do. And you answer because that is what immigration lawyers do. The truth is, you don't have to be the one answering every single time. Staffy Live gives you 24/7 bilingual intake specialists who handle those urgent calls with the same empathy, precision, and professionalism that your clients expect from you. And with Staffy Outsourcing, the casework that absorbs your nights and weekends disappears from your plate. Document collection, forms, evidence, packages. They prepare everything. All you do is review and submit to USCIS. I-130s, I-45s, waivers, adjustments, and more than 18 additional immigration case types. Staffy's team handles the workload so you can focus on the legal strategy that only attorneys can provide. Hundreds of immigration attorneys already use Staffy Live and Staffy Outsourcing to reclaim their evenings, their weekends, and their peace of mind without sacrificing client care. And right now, your first 3 cases are free when you get started. Visit staffy.cc or call 786-891-5619 or click on that special link in the show notes. Because you deserve a practice that grows without burning you out. We conclude then with Padilla-Perez v. Bondi, published by the Second Circuit on February 5th, 2026. This case is about due diligence for equitable tolling and motions to reopen. Mr. Padilla is a lawful permanent resident from Panama. At least he was beginning in 1990. But presumably as a young man, he began getting in trouble and he's got quite a few drug convictions. It led to his physical removal to Panama in 2011. He's still there. But here's the thing. New York law changed recently such that Mr. Bonilla is no longer considered to have drug convictions. That includes the New York Criminal Procedure Section 440.101K, a very important law that, quote, authorized the judicial vacatur of all convictions, end quote, or at least all marijuana ones from a certain time, and that very much appeared to be based on a presumed procedural or substantive defect in old New York marijuana cases. Remember that. New York Criminal Procedure Section 440.101K. That New York law was passed in March 2021. But the first law that Mr. Bonilla is relying on for another of his convictions was passed in August 2019. Mr. Bonilla claims he first learned about all these legal changes by chance in March 2021. Seems he filed a motion to reopen shortly after with the help of an attorney. Must have been a complicated motion, too. In that motion, he argued that the subsequent change of New York law rendered his convictions an improper basis for removability, way back when. The BIA, however, was not swayed. Recall from the decision discussed just moments ago at the top of the episode from the BIA, motions to reopen must be filed within 90 days of the removal order. Now, you can equitably toll that deadline, and that change of law has been considered a proper ground for equitable tolling, but still, you must establish due diligence when doing so, that is, since the change in law. The BIA didn't see due diligence in bringing the motion based on changes of U.S. law from an individual in Panama. Mr. Bonilla then filed a motion to reconsider a few months later, shortly after the Second Circuit concluded in United States v. McNary that cocaine convictions like Mr. Bonilla's first conviction in 1993 were not, in fact, matches to the federal definition of cocaine. Episode 189. And indeed, that's how it's done. Definitely diligent there. Still denied by the BIA. As what must be news to New York immigration attorneys, the BIA denied that motion to reconsider in deeming United States v. McNary no big deal, reasoning, quote, it had long been true that a cocaine conviction under New York law did not categorically qualify as a removable offense under applicable federal law, end quote. Do tell. And Minter sure does seem powerful, quote, the government concedes that Mr. Panilla's 1993 conviction for attempted sale of cocaine would no longer provide a ground for removal if his removal proceedings were reopened, end quote. That's New York Penal Law Section 220.391, and it would appear to be an admission by DOJ binding everywhere that it is not a removable offense. Attempted sale of cocaine. And by the way, the BIA and the Second Circuit assumed, but did not decide that New York Criminal Procedure Section 440.101K also waives all the marijuana stuff for immigration purposes, making this the first precedential immigration decision to address New York Criminal Procedure Section 440.101K, at least that I'm aware of. And I'm aware of all of them, right? The Second Circuit didn't go quite as far as I'd like, but this is a very helpful decision for the immigration applicability of Section 440.101K. Because a lot of that was assumed away below, the dispositive issue here was, did Mr. Panilla's motion warrant equitable tolling? It did, reasoned the Second Circuit. So, to get equitable tolling, you need extraordinary circumstances that prevented a timely filing, plus reasonable diligence. Explains the Second Circuit. The BIA skipped over the extraordinary circumstances portion, but again, the Second Circuit seems to see a strong claim, even as it expressly punts on whether a change in law can actually qualify. Too bad that. But on to diligence then. Good for Mr. Bonilla here, that it was all skipped and we're only talking about diligence. The Second Circuit cleans up some prior precedent to make clear that Mr. Bonilla and those like him need not establish diligence through the entire post-removal order period. They only must do so to pursue their rights diligently when a change of law occurs. Those rights only become possible post-change of law, that is, the rights to pursue diligently. And that seems like a big holding in and of itself. Tethering diligence to New York's change in marijuana laws also furthers what the Supreme Court has said about equitable tolling, noting, quote, the core purpose of equitable tolling is to escape the evils of archaic rigidity and to accord all the relief necessary to correct particular injustices, end quote. Love that quote, not gonna lie. And it's only reasonable diligence, folks, not maximum feasible. So what would be reasonable to expect of someone like Mr. Pena? That's the question, explains the Second Circuit. Someone who has already been removed and lives abroad. While agreeing with something the Fourth Circuit said a few years ago, if memory serves, quote, "We accordingly do not expect the petitioner to continuously monitor public sources for years on the unlikely chance that he might learn something which would be useful to his case," end quote. Nor need the non-citizen keep asking attorneys for updates. Quote, "When a petitioner has no reasonable basis to expect that investigation would uncover relevant information, then his decision not to investigate is not a failure to exercise due diligence," end quote. That seems pretty important too. Relying on Fifth Circuit precedent of all things, the Second Circuit explains that as almost all non-citizens are not immigration lawyers and many are poor or don't speak English fluently, courts should consider, among other things, whether the non-citizen, 1, had the means and capacity to learn of and act upon the change in law, 2, took reasonable steps to investigate and pursue relief, and 3, acted reasonably swiftly to file his motion to reopen after discovering the material change in law. And as here, quote, "Principles of equity especially counsel in favor of tolling when it is evident that the basis for the petitioner's removal may now be invalid," end quote. Turning then to what the BIA did here. They pretty much simply dinged Mr. Bonilla for waiting 2 years or so after New York amended some of its laws. Insufficient, explains the Second Circuit. Quote, "The test for equitable tolling, both generally and in the immigration context, is not the length of the delay in filing the motion. It is whether the claimant could reasonably have been expected to have filed earlier," end quote. "So please do it over," said the Second Circuit. Remanded. So, as such, congratulations, Scott Folletta and Jill Applegate of Neighborhood Defender Services of Harlem, New York. And that is Bonilla-Perez v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.